and welcome to Season 3, Episode 5 of ARBinBRIEF, a practical video guide on hand-picked arbitration issues. I'm Reshma Oogorah and a member of the organizing committee of ARBinBRIEF. ARBinBRIEF videos, in collaboration with Equal Representation in Arbitration Pledge and Lagos Chamber of Commerce International Arbitration Center, offer a quick resource to consult on issues that arise in international arbitration while showcasing talented arbitrators. It is my honor and pleasure to introduce our arbitrators for today, Elizabeth Oger-Gross and Mercy Okiro. Elizabeth is a partner in White & Case's International Arbitration Group located in Paris. She's qualified in New York and France. She has significant experience in commercial, construction, and investment disputes. Elizabeth is both common law and civil law qualified and has oral advocacy experience in both English and French language arbitrations. She has been involved in arbitrations conducted under a number of institutional rules. She also has substantial experience in cross-border litigation, and she sits as arbitrator. Mercy is an advocate of the High Court of Kenya, a trained arbitrator, accredited mediator, and construction adjudicator, as well as an adjunct faculty member at the Kenya School of Law and Strathmore University. She is on the panel of neutrals of various institutions locally and regionally, as well as a member of the Court of Arbitration for Sports in Lausanne, Switzerland. Mercy was listed as one of Africa's most promising young arbitrators in 2020 and 2022, and named second runner-up ADR Practitioner of the Year in 2021 by the Law Society of Kenya, Nairobi branch. Now, our esteemed arbitrators are here to enlighten us on arbitrating in African countries and with African parties. This is currently a hot topic, especially since the English court decision of Nigeria and PNID came out in October 2023. Now, Elizabeth, if I could start with you, what has been your experience in arbitrating in Africa overall, as opposed to on other continents?
Thank you so much for having me, Reshma, and all. I'm delighted to be here. I can't say that I have seen many real differences with regard to Africa as a whole vis-a-vis other continents or jurisdictions. And what I mean, of course, is that I'm not sure one can generalize. The continent is very diverse, although I've, of course, not arbitrated in all or even close to most African countries. From the ones in which I do have experience, either as arbitrator or counsel, the more salient differences seem to me to be between African jurisdictions, and in particular, owing largely to the legacy of colonialism, the legal traditions in African countries are very different. Some have legal systems based on the common law, others on the civil law, and among the latter, even the legal traditions can be quite different. And then there are some that are mixed. And then there are also recent influences, such as, for example, OHADA, which are common to some African countries, but not to others.
Well, thank you. Thank you very much for sharing these insights. And to follow up on that, do you see differences in approaches amongst the various African jurisdictions?
Yes. So as I started to say in response to your previous question, the origin of the legal system is quite important in shaping how lawyers and parties see arbitration. For example, countries with civil law legal systems tend to approach arbitration with a greater emphasis on documents, less on witnesses, which is not to say, of course, are not witnesses, but there's less focus there. And perhaps there's also a greater focus on the law than on the facts. And those are obviously gross generalizations, but I don't think they're nonetheless unfair. In common law-based systems, there tends to be a greater emphasis on witness testimony and the tradition of cross-examination. There's also a greater emphasis on document production, to name just a few differences. And while there is, of course, an international arbitration culture embodied in the spirit of the IBA rules on the taking of evidence in international arbitration, which is supposed to be somewhere between the common and civil law and generally succeeds in that, and while that international arbitration culture does cut across national differences to some extent, those differences nonetheless remain, and they are felt between African countries as they are elsewhere. One other difference that I've noticed is a great difference between African countries and whether they tend to have institutional or ad hoc arbitration. And there again, those are local differences.
Thank you. These were very interesting. Well, if I could now turn to Mercy. Mercy, as an African arbitrator based in Kenya, do you think that it is appropriate or fair to make a distinction between arbitrating in Africa and the rest of the world?
Okay, thank you so much, Reshma, for this opportunity. And I will just perhaps continue to answer what Liz has put out, that first of all, as Africa, we're not a monolith. We just happen to be on the same continent, so that outside of the legal systems, we really have to distinguish in terms of, first of all, culture. Just Africa itself, we are a people of different culture. Aside of the legal systems also, just looking at East Africa, for instance, we have right now about 7 countries forming the East African community, and we have civil legal systems within the same community. We also have a language issue where we don't all speak the same language. Also looking at the role of the courts in arbitration, not all courts treat arbitration similar, and also not all governments or states, as it were, support arbitration in the same way. And of course, you must understand, as Liz has said, that most arbitration here is ad hoc, although we have a proliferation of institutions, and those also should be looked at if we intend to arbitrate on the continent. Lastly, I'd also say the laws, the substantive laws that exist that support arbitration, and also the existence of rules. Some countries have more than one, some countries have nothing, others have just developed. So you have to really take those factors into account on a basis of country by country, and not as a monolithic continent. Thank you.
Thanks, Mercy. Well, this is becoming more interesting. Since most of your appointments have been seated in Kenya, can you share any procedural rules or laws which are unique to Kenya and which arbitrators and counsel should be aware of when dealing with Kenya-seated arbitrations?
The first thing, thank you, Reshma. The first thing I'd say is that Kenya does allow documents-only arbitration in our Arbitration Act of 1995, which we hope to amend soon, sooner than later. That's number one. We also have the backing of the Chartered Institute of Arbitrators, Kenya branch 2020 rules, which are pretty modern, and those are usually used by most domestic arbitrators here as a complement to the Act, whereby you find provisions for matters such as consolidation, joinder, the issues of multi-party arbitrations, timelines for arbitrators to publish awards, either it's an oral hearing, documents only 60 days. We also have expedited procedures. Our roles as arbitrators here, also we enjoy arbitral immunity, because that is also something you have to consider, and it ties in with, you need to know also, as Liz was saying, do you want to be in a country where an arbitrator enjoys immunity? That is, if that is the seat of your arbitration. Lastly, our court is very reluctant to interfere with arbitration, apart from the provisions of Section 10, which roles have been listed, so that arbitration is generally respected in Kenya. And we also have, of course, institutions here that are also institutional arbitration centers that have been recognized. Thank you.
Thank you, Mercy. Now, if I could redirect the discussion a bit, Elizabeth. We've all heard about the recent Nigeria PNID English court decision. Given your experience arbitrating in Africa, what advice do you have for arbitrators sitting in an arbitration in an African seat and or with African parties?
Yes, so some general comments before commenting very briefly on PNID, which of course we could discuss for hours. Preparation for arbitrating in Africa requires the same thing as elsewhere, being prepared, having read the submissions, having understood, having asked formulated questions, also understanding the local context, including any local requirements from the arbitration law or anywhere else in the law, and checking any local particularities, including, as Mercy said, regarding arbitrator immunity before accepting. Although at least in my experience with certain African countries, the immunity provisions have been quite similar to elsewhere. With regard to PNID, there's so much to say, in particular with regard to arbitrators' obligations to take the whole picture into account and not follow a narrow view of procedural due process, no matter where it leads, but we don't have time to get into that. What I will say, perhaps, is mention certain allegations that appear in the English court decision about corruption and bribery, and certain allegations of cultural practices. In that decision, some individuals had explained certain payments to government officials as being cultural, in particular to assist with medical treatment. So the idea was, no, this wasn't a bribe. It's a particularity of our culture that we help people with payments for medical treatment. And without getting into the specifics, I think my general message would be that while it is super important to pay attention to the cultural context in Africa as elsewhere, it's also important not to allow parties to use a certain alleged cultural context or practices as an excuse where that may not be warranted.
Thank you, Elizabeth. Well, Mercy, I was wondering if you would like to share any thoughts on the PNID case and perhaps any relatable experience from Kenya.
Thank you, Reshma. As Elizabeth has said, I think PNID is pretty hot right now. We had a whole 4-hour discussion last week, so I'll not get into it as much. The only thing I'd like is to also put parallels between PNID and a Kenyan case, World Duty Free versus Kenya, which is an exit arbitration. And it also turned on similar grounds whereby one Mr. Ali basically gifted the president, and therefore that was now pre-contract, and then the contract now had the arbitration clause. And now then it becomes, is it cultural that we gift people before tenders or contracts are signed? If the president is gifted, does that then bring us as the state, the people, the public, now do become liable? So that such issues, gifting is common in Africa, no problem. But then now you want to ask yourself, what is this gift? Does it then become corruption, or does it become such that it's at the center of the actual proceedings and can cause the matter to turn on whichever side? So that is pretty interesting that after World Duty Free case, we have this PNID decision still happening close to 20 years later. Yeah, so very important to note.
Thank you. Well, how interesting. Like Elizabeth said, we could spend hours talking about that. But since we only have a few minutes left, let me ask Elizabeth. Elizabeth, what advice would you give to counsel representing African parties in arbitration in Africa?
So very briefly, I have found that it is even more important as counsel, as with clients elsewhere, to create face-to-face relationships, both with African clients and with African co-counsel. It's not enough to stay at one's desk, in my case in Paris, and send emails or get on video calls to discuss strategy, to gather facts, etc. It's extremely important to go there, to meet them, to create relationships, and the result in the arbitration is much more likely to be positive. And in addition, it's just a much nicer way to exist.
Thank you, Elizabeth. Well, that was very helpful. Mercy, from your perspective, what advice would you like to give counsel representing African parties in arbitration in Africa?
Thank you, Reshma. On my part, just to add what Elizabeth has said, increasingly, we have more and more people actually getting into the international arbitration sphere, and you find countries like Kenya increasingly now having local firms representing us in international, whether it's exceed ICC matters. My clarion call to counsel who come to represent or act for clients in Africa, it's simple. Capacity building, you'll need to work with local counsel and local law firms so that even as you're leading them, you're building capacity, because that trust has to be established. And increasingly, we're moving to a place where we want to see more and more Africans representing clients in matters that are seated here, or have Africans as parties, or Africans involved in whichever way. The other thing is mentorship. Consider tribunal secretaries, consider having expert witnesses from here, consider using facilities here like our arbitral institutions, so that we're also developing our arbitration practice in Africa, even if those coming to represent parties are not from within the continent, as for example, Liz. Yeah, that's what I'd say. Thank you.
Thank you. Thank you very much for saying that, Mercy. Well, we have come to the end of the discussion and we'll be moving to questions soon. So it seems from the discussion that there is no monolithic way of arbitrating in Africa. So what would be your final thoughts on this topic for our audience? If I could ask Liz first and then move to Mercy. Thank you.
So I think that really sums it up. Reshma, Africa is a vast continent with many differences between countries, with different legal traditions, and it's really those national contexts that need to be understood. And also, I'll just say that I agree completely with everything that Mercy just said in her last answer.
Final thoughts, Mercy?
Thank you, Reshma. My final thoughts really, outside of everything I've said, I'd just like to emphasize three things. Number one, prepare just as you prepare in any other arbitration. Liz has already covered that. Number two, you must understand issues of politics and government interference, because unfortunately those factors do come into play in arbitration here. Number three, mentorship and capacity building of the legal fraternity where you're arbitrating or where you're representing counsel. Yeah, those three, and then we're good to go. Welcome to Africa.
Well, thank you. Thank you very much to you both, Elizabeth and Mercy, for this incredibly insightful discussion. We have come to the end of this webinar. We would also like to thank our partner organizations, ERA Pledge and LASIA, for their invaluable support. For those of you who are joining us live, we will now move to the 15-minute question and answer session. So please use the link in the chat box to join us on a separate Zoom session. For those of you who are watching us on YouTube, our video ends here. Thank you very much for joining us. To see future ARBinBRIEF videos on handpicked arbitration issues, please follow us on LinkedIn and like and subscribe to our channel on YouTube. We would love to hear your comments and feedback, and you can register for our next episode on www.arbinbrief.com or from our LinkedIn page. We do look forward to seeing you there next time.